Good day, Crime Talk aficionados. My name is Scott Reich, and this is Crime Talk. It is Friday. I don't know about you, but it's been a long week. So let's get to the docket. First, Johnny Depp and his lawyer girlfriend, that's right, Lori Vallow. A couple of thoughts about the motions and the response from the government. We have an example of a situation where I hope this means the relationship is over. Putting witnesses in jail. Yeah, think about that. Don't get too outraged. Wait till you hear this. Do not do this. It never, ever works. And then our dumb criminal of the day. Let's talk about it. All right, aficionados. Yes, this is Crime Talk, our Friday edition. As I said in the intro, it has been a long week. I can tell you that for sure. But we are going to get rested up over the weekend. And we've been thinking about making a couple of changes. But if there's a particular content that you would like to see, let me know. Let me know in the content. We're here for you. All right? All right, let's go ahead and get to the docket. But before we do so, let's take care of those administrative matters. That's right. You know the drill. Subscribe if you haven't. Like if you do. Leave me a comment below. And make sure you hit that bell for notifications of when we go live or put up new content. And yes, finally, you can listen to us anytime on your favorite podcasting app. And man, we hit that 1 million mark, and then all of a sudden we are taking off. So thank you very much. So let's go ahead and open the docket for September 23rd, 2022. First, let's talk Johnny Depp, okay? Johnny Depp has cozied up to a new lawyer girlfriend, and apparently she was at the Virginia trial. That's right. Johnny Depp's newly revealed romantic relationship with his former attorney, Jolie Rich, was apparently hiding in plain sight during his defamation trial against his ex-wife Amber Heard earlier this year. Look at these pictures. That's right, right before our very eyes, but we were so focused on the horrible Amber Heard, we did not see the obvious. That's right, failure to see the forest because we're focusing too much on the trees, I guess, or something like that. Anyway, well, Rich did not represent Depp in the trial in Virginia, but she did fly to Virginia to support him in court. Now, the two were reportedly photographed sharing light moments, walking in lockstep, and getting out of the same vehicle. The actor won the civil trial, obviously, and was awarded $10 million worth of damages after a jury found Miss Heard had damaged his career with the unfounded abuse allegations. Now, Rich, a London-based married mother of two, represented the old Pirates of the Caribbean franchise movie star in his losing 2020 defamation lawsuit against the British tabloid The Star. Rich is reportedly in the process of obtaining a divorce and had no obligation to attend Depp's most recent trial, but instead came to show her support, and that's apparently when their relationship heated up. Now, there's no professional obligation for her to be there. It was personal, according to sources close to her, apparently. Now, Depp's former attorney isn't the first counselor he's been affectionate with. Earlier this year, Depp was rumored to have been dating Camille Vasquez, who represented the Heard case. Now, Camille Vasquez denied those rumors, and I frankly believe her, because that would be completely unethical to be dating your client in that type of a situation. She seems very honest and ethical, so I believe her, other than basically it was strictly business. Hey, and it's Friday. We can certainly lighten it up with a little Johnny Depp gossip news, right? That's right. So a few thoughts on the Lori Vallow matter. I went back through several of the items on the docket in this particular case. And something that I thought was interesting was that the attorneys for Lori Vallow made a specific request for discovery in regards to any statements made by co-defendants, prosecution witness, or prosecution witnesses to the prosecuting attorney or to the prosecutor's agents, okay? And they stated, upon information and belief, the defendant has reason to believe that many of the witnesses and prospective witnesses living in Arizona, Utah, Texas, and elsewhere have been having regular contact with the prosecution and or agents thereof. None of these witness statements have been disclosed. The defense is concerned about ongoing issues of discovery violations. And there was another couple of requests, but it really meant nothing. But the government's response, I was going through, and I thought this was interesting. And in regards to that first request, the prosecution stated the state has no objection to the substance of this request, but objects to the assertion that the state has not complied with the requirements under the Idaho Criminal Rule 16. That's the rule for discovery. Prosecution has to give you everything that they have. The state has complied with this request and will continue to comply. And then they go on and cite some typical stuff that you always see in these kinds of responses, which is the prosecutor doesn't have a duty to collect evidence, nor is there a constitutional requirement that the prosecution make a complete and detailed accounting to the defense of all police investigatory work on the case. Obviously, it'll be memorialized in a statement. The prosecutor is not required to deliver his entire file to defense. I agree, not all of it, but pretty much close to it. And then it says the defense asserts that many of the witnesses and prospective witnesses living in Arizona, Utah, and Texas and elsewhere have been having regular contact with the prosecution and their witnesses. Where the defense has not provided any specific allegations to support this assertion, the state is unaware of what contact the defense is referring to. Any statement made to law enforcement by witnesses are provided in reports, and discovery will continue. Any statements that are discoverable will be provided on their ongoing Rule 16 obligation, standard response. But then something interesting. It says the Idaho Constitution, Article 1, Section 22, subsection 5, provides the victims of crime the right to communicate with the prosecution. A similar right is found in Idaho Code, specifically Section 19-5306, subsection F. The state is unaware of any authority that requires the state to notify the defense of every communication it has with a victim or witness. Further, the state is unaware of any authority that construes the meaning of the word statement so broadly as to include every question or concern raised by a victim or witness to the state. Such an interpretation is inconsistent with the law and with realities of litigation. So it makes me think that there's some sort of jousting going on here, that the defense feels as though, say, for example, there's nothing that says that the prosecution, every time they notify the victims in this case, for example, the Woodcocks, of an upcoming event, of an issue, that does not necessarily constitute a statement. I would agree with that. I can attest to this, that after every court appearance, if there's a victim identified in the case, they get notice of what took place and when the next court date is, and if they choose to be there, they can do that. Sometimes victim advocates notify the victims and witnesses personally. Sometimes they put it in a letter. Those communications, though, are usually strictly prohibited to be turned over to the defense. Frankly, I've seen litigation to try to get those communications, and there's little to no luck in achieving that whatsoever. So I'm not sure what kind of fishing expedition the defense is going on there, but there seems to be something to the effect that they're trying to get all communications between the district attorney's office and witnesses. Normal victim-witness communications doesn't cut it. But I thought that the response from the district attorney was interesting, since they really didn't go into specifically the witness communications, but they said, hey, even if we did have communications, basically we're not entitled to turn that over under the law. And I think the prosecution is correct in that response. So just something to think about. I think the defense is finally realizing, hey, we have 140 witnesses to prepare for at trial. How do we know we have everything? Let's shoot a request over to the prosecution. Maybe they'll do a little bit of work for us. Now, I think that Lori Vallow's attorneys seem very ethical. They seem very experienced in litigation, and I think they'll do a fine job representing her to make sure that they hold the government to their burden of proof. And the prosecution should say, we gladly accept that burden, we embrace it, and we're going to prove the case beyond a reasonable doubt. We'll see. Hopefully things are going to heat up, because guess what? In just a few short weeks, we're going to have the hearing with Lori Hellis on October 13th in regards to trying to get access to all these sealed dockets and filings and hearings in this particular case. And that's what I'm waiting for, ladies and gentlemen. Unless, of course, the judge denies it. Like I think he's probably going to say no cameras in the courtroom. But we'll wait and see. Please go to crimetalksearch.com, sign up for a background subscription service. You'll be happy you did. If there's anyone out there you were ever curious about what was in their background, now is the time to do it. If you're going to get involved with somebody, now is the time to do it. When you go to crimetalksearch.com, you put in the name, literally millions of public records are searched, and a report is generated. And it's going to give you a report. If they have multiple social media accounts, you're going to find it. If they have multiple phone numbers, multiple email addresses, it's going to be found. And more importantly, you're going to get information regarding criminal history. Hopefully the person you're searching has none whatsoever. But if it's there, it's going to be found. You're going to get everything you'd want to know, whether you're going into business or whether you're going into a personal relationship. You're going to be able to find out the information you want to know. So go to crimetalksearch.com, sign up today. You'll be happy you did. Next on the docket, I think this is an example of when you know a relationship is over. Look at this video. A Texas woman allegedly plowed over her boyfriend after an argument, leaving him with serious injuries, while she claimed to the police officers he stepped in front of the car. Look at that step right before he got hit. What was he thinking? My goodness. As you can see, the surveillance video appears to tell a little bit different story than the driver. The victim is seen walking in the median between the Spectrum store and the entrance to a Walmart. On the other side of the entrance at the Walmart gas station, the suspect vehicle rounds the gas pumps, crosses the entrance road, and then jumps the curb where the victim obviously jumped in front of the car. Right? Yeah, as you can see. The victim is seen trying to get out of the way of the video. Now, the video cuts off and then resumes when it shows him lying on the concrete there. The incident took place on September 4th. The victim, originally in critical condition with several fractures and displaced vertebrae, apparently is now in stable condition. Andrea Eastwick was arrested on September 20th for aggravated assault with a deadly weapon, as she should have been. Now, according to an affidavit, Eastwick and the victim were in a relationship and had decided to separate. I'm thinking only one person decided to separate here, and he's in the hospital. Well, Miss Eastwick told the police on the night in question they had been down to Austin, had a couple of adult beverages, and on the way home, Eastwick said the victim was hungry. So they stopped at the Walmart gas station, and while there, they apparently got into an argument. He got out of the car and began walking towards the frontage road. Eastwick then told investigators that she got back into the car to catch up to him and to keep him from walking into the road. Eastwick then told investigators that she got back into the car to catch up to him and to keep him from walking into the road. When she got close, she said, he stepped in front of the car. You be the judge, ladies and gentlemen. You saw the video. I mean, look at that leap that he is making just to set Miss Eastwick up to make it look like she tried to run him over. Now, according to the affidavit, Miss Eastwick didn't call 911. Instead, she drove home and called her mother. And then the mother called 911. Eastwick told police she couldn't find either her cell phone or the victim's and was simply too scared. Police obviously believe that the defendant, Miss Eastwick, knowingly and intentionally or recklessly struck the victim with her motor vehicle. Police are still looking for a couple of eyewitnesses, but they think the videotape would be good enough. I've seen people freak out of a minor accident and leave. I get it. People panic and freak out. But Miss Eastwick, don't go with he walked in front of the car. I'm telling you, it's not going to work. Jury's not going to believe it. Start taking some anger management classes. Move on. The relationship is over. To the victim who got run over, please do not forgive her. The relationship is over. I've always said if someone in a relationship is going to send somebody else to jail, it's a good sign the relationship is over. I think it takes it to new extremes when they actually run you over with the car. It's over. And get a good attorney. You're going to get a big settlement too. Next on the docket, a woman, a witness, held in custody by the court. A witness? Listen to this story. An Oregon woman was held in jail for 9 days after she had horrific things done to her by an older man convicted of various sexual crimes. We're not going to go into the specifics because I think we went into the specifics just a little too much in a story yesterday and it got us demonetized. I know. We'll put a link to that video in there today if you didn't get that notification to watch it because of whatever YouTube does when they don't like words. Well, needless to say, this unidentified woman was one of this Christian Alexander Sanchez's many victims who he held against her will back in 2020. And how did he do that, you say, Scott? Well, he used a lighter, a hammer, and a screwdriver to help keep them against their will, according to the prosecutors in this particular case. Now, the prosecutors forced the woman to stay in the Jackson County Jail for 9 days between September 6th and 15th to ensure that she would testify during a trial held to commence on September 13th. As a result of her testimony, Mr. Sanchez was found guilty on September 16th for various sexual crimes. Too many to go into, but you get the picture. Now, Mr. Sanchez will be sentenced on October 6th, and he's going to spend a very significant time in prison. Well, the woman ordered to be held in jail until the end of the trial by Judge Lorenzo Mejia. Now, apparently, Oregon has a law that allows district attorneys to hold a material witness, which includes using a person that contains viable evidence against the defendant. We all know who the essential witness is. Clearly, the prosecution needed this witness to come into court and identify, after telling her story, what took place, and say, who was the bad man that did this? And they point to the defendant over there at the defense table and say, let the record reflect that the witness, with great certainty, has said that is the bad man who did these things to her. Okay? Now, while the 20-year-old's attorney insisted that the use of an ankle monitor would have been more appropriate, the judge wanted to ensure the victim would be present to testify. And you think, wow, Scott, this is crazy. I've never heard of this. It doesn't happen that often. And really what it happens with, in a situation like this is somebody has to usually be subpoenaed to court. They don't show up. The arrest warrant issues for their arrest for not showing up to court, and then they hold them until they testify. Very similar here, but this Oregon statute provides a pretty unique tool for the prosecutors to do this. Now, it doesn't sound like this was a first time that they had an issue with this particular witness. Apparently, she has a track record of disappearing because she is battling addiction. Not surprisingly, right? No one can find her. Prosecution can't go forward if the speedy trial clock is ticking and they don't have a witness. Now, I understand it looks like the prosecution probably, but they were within the law, apparently, held her in custody against her will, apparently, so that she could testify, which she ultimately did. It was probably the best thing for her because if she has a drug addiction, hopefully she got clean for a couple of days and was able to testify and was obviously there. And needless to say, they got this bad guy, Mr. Sanchez, who had previously been arrested, as if I didn't note it already, back in 2012, and he pled guilty to sex crimes involving minors, where he was sentenced to prison. Well, now 30 years old, he faced 27 of those charges after he sent various photos to, let's just say, adolescents under 13, of which he did terrible things to at least 3 of them. Okay, so don't be offended by this. She had a drug issue. She disappeared for long periods of time. The DA was probably to justify this so this guy would not go free. Obviously, there was some balancing of interests there, but I think society's better interest was to keep this young lady so that she testified and this bad guy doesn't go free. Okay, let me give you some free legal advice here, ladies and gentlemen. Do not do this. If you are charged with a crime, do not try to tamper with a witness. Do not try to do anything to a witness. It is bad. If you look at most death penalty cases, a lot of them, I don't want to say most, but a lot of them, what's the issue? That's where they try to do bad things to witnesses. That's bad. Don't do it. It never, ever works. Take a look at this guy. This guy allegedly fatally shot his ex-girlfriend and is accused of trying to hire someone to kill 2 other people involved in the case. That's right. Robert Tarr was indicted on 2 counts of solicitation of murder for hire. The sheriff's office said that Mr. Tarr was already in custody at the jail for first-degree murder and attempted murder charges when he was indicted as it relates to these new allegations. In November of 2021, Leslie Reeves and Christopher Smith were going on a date at a bar in Farmersville, Illinois. The next day, a family member reportedly requested a welfare check on Reeves, and deputies responded to a home where Reeves was found shot to death in the living room. Smith was located in the kitchen, suffering from gunshot wounds to the head, according to the affidavit. Now, while in jail, sometimes between December of 2021 and June of 2022, Mr. Tarr allegedly tried to hire someone to kill Smith and a Montgomery County deputy. Even worse, right? A cop. Jeez. According to the sheriff's office, Mr. Tarr's bond was previously set at $2 million. And before her death, Reeves, an advocate for domestic violence victims, owned and operated a fitness studio and a party venue that offered women yoga, self-defense, and firearm classes, and she reportedly leaves behind 2 children. These murder-for-hire schemes never work, ladies and gentlemen, and I mean never. Please don't do it. I'm telling you, it never works. If the person you ask is not in custody, guess what? They're going to the police. If you ask somebody in custody, guess what? They're going to the police, and they're going to get a better deal on their case. It's always the way it works. Always. Okay? And the one case where I had where it looked like it was going to work, it still didn't work because somebody talked about it. The cops listened to the tape, and they were over there at the scene and stopped it all. I'm telling you, it's the dumbest thing you can ever do. You do something wrong, sometimes you got to accept that responsibility for that and take your lumps, right? You don't go whacking witnesses. Never, ever, ever, ever do that. Never. And finally, our dumb criminal of the day. A man claiming to be a sovereign citizen American was arrested after threatening to place a lien on deputies' homes while being arrested. Police arrested 38-year-old Corey Wilton Chrischester on Thursday in Fort Lauderdale after Chrischester was pulled over for driving a car with no license plate. That's one of the things the sovereign citizens do, is that they don't need to get a license for their car. They don't need a license, etc. Interesting group of individuals. Most of them are very nice. They're harmless. And usually a couple of days in jail gets their attention that maybe their beliefs aren't that strong after all. Anyway, the officers initiated a traffic stop, and Chichester refused to lower the window of his Ford Focus before putting his hands out of the window and handing officers false documentation indicating that he was a foreign national because he's a sovereign citizen, because he is more like a corporation. That's right, more like a corporation than a citizen of the United States. It's almost too weird to get into. Nice enough, but we have little pockets of them, and I'll explain in just a minute. But Chichester continued to refuse to get out of the Ford, causing deputies to shatter a window and pull him out of the vehicle. Police conducted a records check, which showed Chichester had outstanding arrest warrants and a suspended Florida driver's license, because he doesn't need no license. While in custody, Mr. Chichester threatened to put a lien on the deputy's property and freeze all their assets because of the arrest. He's been charged with 10 counts of threatening a public servant. That's another thing that sovereign citizens like to do. They like to put liens on people's homes, usually judges, public officials. Completely clouds the title. It's a big deal. I'll just say there were some sovereign citizens that tried to do that here in the Denver metropolitan area years ago and have extensive prison sentences to think about their conduct. So, Mr. Chichester, stop it. Okay? Just stop it. Your theories are never going to work. They're never going to work. I'm sure Mr. Chichester will file 10,000 pleadings, 10,000 pages long, so somebody has to go through and read it, and it will simply clog up the system. But normally when he gets in front, a sovereign citizen gets in front of a jury of his peers, they promptly convict them of the crimes of which they are charged. So, Mr. Chichester, stop the nonsense, all right? It's ridiculous. It's dumb. All right. Thanks for watching. Hope you enjoyed the show today for a Friday. Have a wonderful weekend. Don't forget to watch the video that YouTube shut down yesterday, just to kind of stick it to the man, so to speak. And as always, we'll have our weekly recap for you on Saturdays as well. Have a wonderful day. We'll see you next time.